Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Navigating Medical Negligence Claims, Guidance for Families of Deceased Patients. My name is Amanda Pon, and I'm a pupil in Chambers with Ma Wing Kwai and Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and/or industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. Today, we have two speakers for the talk. Allow me to introduce our first speaker, Mr. Jeremy Balang. He is a senior associate of this firm. He practices in the areas of medical law, personal injury, debt recovery, and general litigation. He was admitted to the Malaysian bar in 2018. He specializes in acting for patients and/or their family members in medical negligence claims against owners and managers of hospitals, healthcare practitioners, including doctors and nurses, and their respective professional indemnity providers. And next, we have Ms. Daphne Ritwell. She is a senior associate in our Dispute Resolution and Individuals and Families Department. She completed her Bachelor of Laws with Honours from University of London in 2016. She obtained her certificate in legal practice in 2017, and she was then admitted to the Malaysian bar in January 2019. Her areas of practice are general litigation, debt recovery, joint management body disputes, probate and administration, and contentious probate litigation. Today, Mr. Jeremy will be speaking first on introduction to medical negligence, and Ms. Daphne will be speaking on grants of representation. The four top points for today are Number one, types of claims and limitation periods. Number two, obtaining discovery of medical records. Number three, damages claimable for medical negligence. And number four, applying for grants of representation. And we will end this talk to conclude with a Q&A session. And so if you have any questions, please don't forget to type it up in the chat box, and we will address the questions at the end of the talk. And now I will pass the floor to Mr. Jeremy to begin our talk for today.
Thank you, Amanda, for the introductions. Good afternoon, everyone. As mentioned, my name is Jeremy. I'm the head of my firm's medical and personal injury department. In particular, we specialize in medical negligence claims on behalf of patients against hospitals and doctors. Medical negligence is a complicated subject. Certainly, there have been a number of reports in recent media about cases involving brain-damaged infants at government hospitals. Most recently, there has been news about one particular case in particular. Perhaps some of the viewers of today's webinar would have seen the headlines about a case where a deceased CEO was awarded a sum of approximately 5 million ringgit as damages. There are a number of very interesting facts about this case. One, the CEO was actually alive when the suit was filed. He was suing as a brain-damaged adult, and his wife at the time was his litigation representative. The case itself was interesting. The deceased was about 56 years of age when he underwent ENT surgery at the KPJ hospital. The surgery itself was no issue, but he had difficulty breathing as a result of the anesthesia following the operation. Allegations were made that he was not monitored properly, and he lost control of his airway, and he collapsed in the ward. Now, very interestingly in this case, his son, the CEO's son, was a doctor himself and was actually involved in the CPR efforts to try and resuscitate his father. And one of the issues in this case was that for some reason, there was a missing piece of equipment. It was an oxygen converter that was used to connect the ambu bag to the oxygen supply. It was missing. So when he had lost his ability to breathe, he was collapsing. This particular item was missing, and that made things worse. So after a very long trial, the court found liability on part of the hospital and the two doctors and awarded the sum. The reason for the sum was because in this particular case, the CEO was found to have earned about 65,000 a month, a very large sum when spread over time. Hence, it resulted in the $5.1 million judgment. That case is emblematic, and not all medical negligence claims will receive that kind of award. Certainly not everyone would earn 65,000 a month, but it is emblematic of the type of cases that deceased patients and or their family members have to face. The number of issues in that case are endless and go far beyond what is reported in the media, let alone what's in the grounds of judgment. So today, let's talk about the kind of claims that can be brought on behalf of deceased patients and their family members, especially in medical negligence. And oftentimes after the death, families are traumatized, they are confused, they don't know what to do. They feel that something has gone wrong, but they don't know where to turn. Perfectly understandable. And this is why we hold webinars like this, so that the public may be educated and greater awareness may be spread. So essentially, when a person dies and a suit in negligence is to be brought, there are two kinds of claims. One is called a dependency claim, and one is called an estate claim. Now, a dependency claim is brought by the dependents of the deceased. So dependents may include the children, the parents, and they would sue for losses incurred by them as dependents of the deceased as a result of the death. For example, funeral expenses. They are usually paid by the dependents, and that would fall as an item there. Bereavement. Now, this is a fixed item for what is essentially mourning. It's at present 30,000 ringgit. There are other items as well. For example, loss of support, which is usually the largest item claimed in a dependency claim. Now, loss of support can mean financial support. Perhaps a practical example. Say I am the child. I am 16 years old. My father passed away as a result of medical negligence. My father was the breadwinner of my household. He earned 10,000 ringgit a month. And of course, as his son, as a minor, he paid for everything. He paid for my school, he paid for the maid, he paid for the house that over my head, etc., etc. So as part of a dependency claim, you would claim this kind of loss. Losses that a dependent like myself in this hypothetical situation would have incurred as a result of the death, which was negligently caused. Now, an estate claim is different. So this is where a person is appointed by the court to sue on behalf of the estate. The practical example is simple. when an estate claim is brought, the court, when seeing the person who is appointed, does not see the representative, but sees the deceased as if that person were before the court, claiming for his or her injuries as if he or she were alive. Under an estate claim, you would claim things like pain and suffering and loss of amenities of life. You would claim things like aggravated damages. There are two completely distinct claims. That's one. But there has been a practice of combining the claims into a hybrid claim for the purpose of convenience. So in a single claim, it could be the case in the earlier example that I gave, that I am a 16-year-old child. My father has passed away as a result of negligence. The plaintiff in this sense would be my mother suing as a dependent on behalf of the other dependents of the deceased, as well as, say, the administrator of my late father's estate. And the court would award damages for both claims, but distinct to one another. So it's important to identify the kind of claim that you have, and the key factor of whether or not you can bring a hybrid claim is the issue of limitation. Now, let me first start by saying that when it comes to the issue of limitation, always seek legal advice. Never attempt to Google search your way into finding an answer. It will not help. There may be factors in any particular case that would warrant a legal opinion on. Never try to understand the law of limitation for yourself, especially in a case where there is a deceased patient. Now, say I wanted to bring a claim against a private hospital. There's an obvious limitation here, is 6 years from the date of the earliest incident. That's the safest way to calculate limitation. If it's against a government hospital, it's usually 36 months. Some may say that it's the same as 3 years, but not really. It just so happens that this year is a leap year. There's a difference in the number of days. Now, when it comes to deceased patients, one must always be mindful of the fact that there are limitation periods running on a dependency claim and an estate claim, as well as concurrent limitation periods. So they run concurrently. In a hybrid claim, you have 3 years. In an estate claim, you have 6 years. You always take the earliest date for the purpose of calculating when you should file your suit by. But the two of them run together. And of course, there may be other applicable limitation periods as well. One must always keep in mind the 36-month limitation period against a government hospital, the 6 years, etc. At the end of my presentation, we will go over various scenarios and we will apply the issue of limitation. But it is always important to take legal advice on this matter and to always file early. If you are out of time, if you are beyond the 3 years for dependency claim, you cannot bring it. You are then only limited to an estate claim. And of course, while it's perfectly viable to bring an estate claim, you are limited in terms of the kind of damages that you seek. So let's talk about the first obstacle all patients face when it comes to wanting to bring a claim in medical negligence, obtaining medical records. It is unfortunately more complicated when a deceased patient or their family members wish to bring it, especially if it's early after the death. So if I were a patient at a private hospital, it is in practice and in theory completely possible for me to request for the records to be provided to me in addition to a report. Unfortunately, there are issues of representation when it comes to deceased patients and their family members. My colleague Daphne will cover the issue of the need for grant of representation. Often enough, there is a distinction that must be made between medical records and a medical report. Countless times patients come to me, they say, oh, I have obtained the records, and they present me the medical report. A medical report is a retrospective document prepared by a doctor based on the records. In a medical negligence claim, you will need contemporaneous evidence, i.e. the medical records that were prepared at the time the tort was being committed, or, well, at the material time the patient was seeking treatment for his or her condition. Medical records may include ICU charge, nursing notes, clinical notes, admission forms, consent forms, operation records, CTGs. The list is endless. May include radiological investigations, CTs, X-rays, MRIs. This is usually not given to the patient. They only give the report. It is important to have the records. It is helpful to have the report. Then there is the other more unique facet when it comes to deceased patients, and that is the inquiry documents. Now, it is practiced in all hospitals, whether private, government, or university, that when something wrong has happened, resulting in, say, the death of a patient or an adverse outcome, they usually investigate it. In the private setting, there is the grievance mechanism that could trigger investigation, though some hospitals have their own, would, even without a patient complaining, investigate the incident, especially in a case where the outcome was tragic. In a government hospital, they would usually call it incident reporting. Now, a patient may make a medical legal complaint, and they would then hold an internal inquiry. So in both situations, the hospitals would form a committee or already have a committee. They would interview the doctors involved, they would review the medical records, and they'll create a report. And that report is usually meant to identify the faults in their systems and to see about improving patient safety, among other factors. Not every death at a hospital is investigated in this manner, but this is something that a patient, the family members of a deceased patient, should look out for when looking to undertake a claim, because they should seek discovery of these documents. And unfortunately, most hospitals, if not all hospitals, would rarely give this kind of document voluntarily. You would require to file an application under the rules of court for pre-action discovery. And in order to do that, you will need a lawyer. It's often a contested fight. The government hospitals will certainly not give this kind of document voluntarily, so which is why the need for a lawyer is of the utmost importance. You need a lawyer to represent you, to go to court, to make the legal arguments that these documents are relevant and therefore ought to be disclosed. The government or the owners of the private hospitals will more often than not make the argument that it should not be disclosed because they are confidential, they are privileged, they're covered, they're protected, etc. But the law is clear. Patients may receive this. There's another issue as to whether or not patients on their own right can receive without the need for a grant. And unfortunately, there's been lots of resistance in this arena by hospitals. I suggest you take legal advice on your specific situation, but I have myself undertaken a case where there was no grant and we applied, and our reasoning was this: that they are beneficiaries of the estates and recognized dependents. They are entitled to receive. If they had filed a suit and sought pre-trial discovery, the court would order the medical records to be disclosed as a matter of relevance. So why should it stop at the pre-action stage? But this is a fairly complicated matter. It is always safer to obtain grant of letters of administration or grant of probate, whichever is applicable, or even resealment if you're a foreigner. Now, the issue of post-mortem reports is often one that arises when it comes to deceased patients as well. Whether or not there is a need for it would really depend on the facts of that particular case. In my experience, only a handful of family members of deceased patients have actually undertaken it because it is a bit culturally insensitive. Many have asked me whether or not there's a need. I would say I would have to look at the case. One reason you would require an autopsy resulting in a post-mortem report would be if you feel that the cause of death is itself suspicious. But if it's obvious, there's really no need to subject the deceased body to such an examination. But sometimes it may yield interesting results. That being said, whether or not it should be done in any particular case is a family decision. That's above all. Certainly, many claims in medical negligence have succeeded without a post-mortem report. That being said, I have also seen cases where families have taken the liberty of undertaking such autopsies and obtaining post-mortem reports, and there's information that's useful in respect of the case. So let's look at the first scenario that's presented here. Mr. A, he's 50 years old. He passed away on the 12th of June 2024 as a result of anesthetic events at a government hospital during an elective procedure on the same date, leading to an on-table cardiac arrest and resulting in his eventual death. He leaves behind 2 young children and a wife and has no will. Number of things here to package. 1, there are 2 limitation periods here. 3 years from the date of his death, which would mean, say, 12 June 2027. But it is always prudent to have it filed by the 11th, the day before. Always play safe. And then there is 6 years from the accrual of action. Now, in practice, we usually take the earliest possible incident, but sometimes it's not practicable to do this as well. So it could be, say, the date he was admitted to the hospital, perhaps, if the allegations which wanted to be brought there. It could be a few days before, it could be a couple of months before. It could be the very first time he came to the hospital, maybe a few months ago, he was diagnosed with a particular condition and then he was scheduled for the surgery later. Now, insofar as his dependence and the issue of the will is concerned, since he left behind no will, it is intestate. He would need to obtain grant of letters of administration. His wife would, in this situation, could be the administrator, though one would have to see whether or not he has siblings or grandparents, etc. That's a whole process which my colleague Daphne will go into. Now, in scenario B, it is unfortunately the case that I have personally experienced a number of parents who come to me. They tell me that their infant children have passed away shortly after delivery, some within a day, some within hours, some after 3 or 4 months of suffering. The longest I've seen is about 4 years. It is always unfortunate, and yet in such an instance, claims are brought, claims are fought, claims are disputed. So in this situation, infant B was born on 12th of June 2024 at a private hospital but passed away 4 months later. And the facts of this case would be that there was a delay in detecting an infection resulting in sepsis and later that infant's death. Infant B is the firstborn child of his two parents. So in this instance, limitation would run from the date of death in October, 3 years, but the earliest incident for the purpose of a dependency claim can be taken from 12 June, which is 4 months prior. You should always take the earliest date in order to be able to have a hybrid claim. In this kind of situation, the grant of representation that would be needed would be a grant of letters of administration. Now, if there are any lawyers watching this, it may seem strange to get grant of letters of administration for a patient that has no assets or liabilities, because in this case, the patient was an infant. Still, it is needed for the person to be clothed with the necessary authority. And the law has seen a number of cases exactly in this manner. Now, in scenario C, slightly different. Madam C is an Australian, 30 years of age. She received treatment at a private clinic in Malaysia, but the doctor failed to give or to recognize the signs and symptoms that suggested that Madam C had a bleed in her brain. Some days later, she collapsed and passed away on the 12th of June 2024 after failed efforts to resuscitate her. She names her parents, her husband, and her son as her beneficiaries, and her only sister as the executor of her estate. Her will, however, because she is Australian, was executed in Australia. Now, the concept of foreigners suing in Malaysia is an entire concept of its own and may be explored in a different talk. But because her will was executed in Australia, and Australia is a Commonwealth country, she can apply for resealing in this country so as to clothe her family with the authority to bring an action in the Malaysian courts. Limitation, of course, would be the same as what I've described earlier, 3 and 6. Now, some points perhaps about the medical aspect of deceased patients and their family members bringing claims. One, there's no step-by-step guide. Some families take time to mourn, some never recover. The best thing I can say is that if you feel that you are able, you can contact a lawyer. You can seek his or her advice regarding the deceased case and what to do moving forward. But I would say that the first priority should always be to the personal matters, to the affairs of the estate. I would say that there is no real need to immediately call a lawyer, and certainly your case will not suffer as a result of not contacting that person immediately. You will have to deal with your family members. You will have to deal with the estate. You will have to deal with funeral arrangements. You will have to deal with memorial issues, all kinds of things. I would say in such a situation, if such an incident were to happen, you can start the process by getting the medical reports, getting the death certificate, preparing a write-up, and then forwarding all of that to your lawyers. And then you let your lawyers take care of what needs to be done while you attend to the affairs of the estate. I have seen some very messy cases involving, as a result of death, an entire family collapses. In one case, as a result of the death of a deceased infant, the mother went into complete depression. Until today, I believe she's still receiving treatment for it. It is the father who has to shoulder the load. And he also had to be diagnosed with depression because he had to take care of his depressed wife. In another case, the family spent a long time mourning, right? Lots of complicated affairs involving probate, involving the will. It's always important to trust your lawyers to do what they need to do while you attend to what you have to attend to do. Of course, your lawyers will get the documents that is needed on their part, but let the lawyers do their work and you do what you need to do. I would say that concludes that part. I will look to address any questions that any of you may have in respect of bringing claims on behalf of deceased patients. But for now, I now yield the floor to my colleague Daphne to talk about the grants of representation.
Hi everyone, thanks for the introduction, Amanda. Thanks, Jeremy. Okay, I will be speaking on grants of representation, which, as Jeremy has mentioned, is required before a family member can bring a claim on behalf of a deceased patient. Okay, under estate administration, there are 3 applications you can actually make. One will be the grant of probate, where a grant of probate will be relevant where there's a will prepared by the deceased before his passing. The second would be grant of letters of administration, where there is no will prepared by the deceased patient. And then there's also resealing. Resealing would be applicable when there's a grant of probate or LA granted by a foreign court under the Commonwealth jurisdiction. So before we look into the types of grant, we will first look at what is an estate. An estate is all the assets and liabilities a deceased person had at the point of their death. There are 2 types of estate. The first one would be testacy, which would be the case where an individual who passed away leaving behind a valid will. The will would take effect upon the death of the testator. In testacy, when we say intestacy, it means that a person dies without leaving behind a will. What happens then in the situation of all persons interested in the estate, usually beneficiaries, can make an application for grant of letters of administration upon the death of the person without a will. You may then ask who would be the beneficiaries of a person who did not leave behind a will. So Section 6 of the Distribution Act sets out the persons entitled under the estate and the manner of distribution. So under Section 6, if a person does not leave behind a will, the first three parties interested under the estate would be the spouse, children, and the parents. And then if these three parties are not around or they don't have a spouse, children, or parents, then we will look at siblings, grandparents, uncles, aunts, great-grandparents, great-grand-uncles, and great-grand-aunts. And then if there are none of these people, then it will be bona vacantia. The estate would go back to the state, the government. The manner of distribution under Section 6 of the Distribution Act is, as you can see on the screen, if the deceased person only has spouse, everything goes to the spouse. If there is spouse and parents would get half each. So if there are two parents, they also get half, and then the spouse will get half. So if there are only children involved, children will be entitled to the entire estate. If there's spouse and children, spouse will get 1/3. Children, regardless 10 kids or 2 kids, they will get 2/3 of the estate. And then if there's parents and children, the parents of the deceased will get 1/3, children will get 2/3. And then if there's spouse, parents, and children, then the spouse will get 1/4, parents will get 1/4, and then children will get half. So under our laws, the children would be the bigger beneficiary. I think Singapore, they are actually equal where there's spouse and children involved. So if there are no spouse and children, then the parents will be entitled to the entire estate. So what is estate planning? Estate planning is to set up a plan that decides who will receive your assets and how your affairs will be managed after you die. How do we actually plan out your estate? So you can do it by way of trust or wills, but today we'll only be looking at wills. How do we prepare a will? The formalities of the will is actually provided for under the Wills Act. So under Section 3, it says that the maker of the will must be of sound mind with animus testandi. So meaning it must be apparent that the testator has the intention to make a will. And then Section 4 of the Wills Act says the testator must be 18 years and above. Section 5 says no will shall be valid unless in writing and executed in the manner prescribed. So what should a will contain? Particulars of the testator, the name, IC, and address. Appointment of executors. Executors would be the person who you want to be managing your affairs after you pass on. Then the contents will be your intention, declaration, and wishes. Let's say my kids are to get everything, or my kids are to get nothing. I want to give everything to charity, or part of it to charity, and so on. And then you have to state the beneficiaries like what I said. So the kids or charitable organizations or parents. And then the date of the will, where the will is signed. And then the signature of the testator has to sign the will, witnessed by 2 witnesses. So these 2 witnesses, it actually can be anyone, but not a beneficiary under the will. So if the kids are entitled to a portion, the kids cannot be witnessing the will. So appointment of executors. An executor is the person appointed to administer the assets of the testator and carry out the wishes and bequests of the testator. They must be willing and capable. They may be a beneficiary. And then usually we will advise client to put in an alternative executor in case at the time when the testator passes on, the executor is, maybe they are residing abroad, they do not wish to take up the executorship, or they have actually died by then or something. So there's actually a backup provided. So Section 4 of the Probate and Administration Act says there can only be a maximum of 4 executors. Representation cannot be granted to more than 4 persons. And then Section 4 sub 3 of the Probate and Administration Act says if there's a beneficiary who is an infant, meaning a minor, or if a life interest arises under the will, administration, meaning where there's no will, shall be granted to a trust corporation or no less than 2 individuals as executors. So what can you dispose of under your will? So under Section 3, it says property or interest in the property belonging to the testator or to be received by the testator. Can be personal, movable property, immovable property, your houses, your shareholding, your partnership. Interest given under the will of another individual. If someone has named you as a beneficiary and you have gotten it at that point, then you can also list that down under your will. What cannot be disposed of by a will? Your EPF and insurance policy. Also only because you are supposed to have put in a nomination with EPF and also insurance policies. Highly recommend everyone to actually place their nominations with EPF and insurance policy. Once you have done that, it actually falls, it doesn't form part of your estate even if you have a will. In drafting a will, we usually also include something called a residuary clause, which would be a catch-all provision. So usually when we prepare a will, we try to be as specific as possible so that your executor knows exactly where to locate your assets after you die. Because if you don't put, chances are your executor don't know your bank accounts, don't know where you have your houses and shop lots. So usually we advise clients to be as specific as possible in their wills. But then if it so happens that there is some assets not listed in the will, then we will put in a residuary clause that says what is left after the debts and administration expenses have been paid off. It should go to, let's say your will, you say it goes to my kids and my parents, and then what is left and not named here can go to my nephew. So that's what we call a residuary clause. So according to Section 8 of the Distribution Act, if your will does not have a residuary clause, it means, and then it comes to light that you actually have some other property that is not specified in your will, and then you don't have a residuary clause. This is a situation where we call a partial intestacy. So let's say if you have 1 million that has not been specifically named or in some funny bank account, then those that 1 million would actually be distributed in accordance with the distribution that we looked at earlier under the Distribution Act, meaning like there's parents and kids, so 2/3 will go to the kids. Parents and spouse, so 1/3 will go to the spouse and 2/3 will go to the kids. So to address this, usually we will put in a residuary clause to make sure it doesn't fall under partial intestacy. So if you have made a will before you got married, under Section 12 of the Wills Act, your will is automatically revoked upon your marriage or remarriage. An exception is where your will expressly provides for an expected marriage in a contemplation of marriage clause. But a divorce, on the other hand, will not affect the validity of a will. A new will may be necessary if you have changed your mind in the course of a divorce. So now we look at the types of grant needed if you were to take action on behalf of your deceased family member. The first one will be grant of probate. A grant of probate would be the grant to apply for, where we apply for if a deceased has left behind a valid will. So who would be the one making this application? The person named as the executor. Let's say it's the spouse. So spouse will put in an application to be appointed. Even if there's a will and you are named in the will, it doesn't give you, you can't bring the will to the bank and say, okay, I'm the wife, I'm named here, you have to release the monies to me. The bank will not release anything to you until the executor goes to court and obtain a grant of probate pursuant to the will. So when we make the application in court, the necessary documents will be the original will, the death certificate, and the IC of executor and the beneficiaries, and detail of the properties. Of course, we'll be filing in what we call a list of assets and liabilities, and also the list of beneficiaries. The process is fairly straightforward. From the day of filing in court, it usually doesn't take more than 3 months. And then once the court issues it, you get it CTC'd by the court, then you can bring it to the bank. The bank will then deal with the release of the funds to the executor. So if there is no will, what the beneficiaries under the estate can do is to apply for the grant of letters of administration. Persons interested can apply, and then usually beneficiaries, like we have mentioned earlier. The court has the duty to consider the rights of persons interested in the estate. The necessary documents similar to the ones needed for the application of a grant of probate, but the person applying may need to show evidence of your relationship with the deceased to show that you're actually the spouse, you're actually the kid or the parent of the deceased, because the court will generally only award it to persons interested. I personally have done one where the parents of the deceased were residing in France, but the deceased had a very close friend in Malaysia. So the friend applied for the grant of LA, the court actually granted it. Of course, we had the supporting documents from the parents in France to say that they are consenting to the friend applying for the grant. So these are the main differences between the grant of probate and grant of letters of administration. So that when there's a will, the person appointed is called an executor, and then they get a grant of probate. If there's no will, the persons interested can apply for the LA, High Court grants, and then, okay, there's a slight difference here. If there's no will and the persons interested applies for an LA, there usually is if the value of the estate exceeds 50,000, the court will require the administrators to provide a bond, like a guarantee, and also to source for two sureties like guarantor with the equivalent amount of estate, so that if, let's say, the administrator absconds with the estate, then the two sureties can step in and provide the equivalent amount of property back to the estate. And then once they have done this, the court will grant the LA. But then if one of the differences is also where it's a situation of letters of administration, where there are houses, like houses, immovable property, for the administrator to actually dispose of the property, like even to the beneficiaries, the administrator actually has to apply to court for what we call a distribution order. So application will say, okay, under the estate, there's spouse, there's parents, there's kids, how much they are entitled, and then get an order from court before they can go to the land office to have the immovable property transferred to their respective names. But if there's a will and the probate is granted, the land office will usually just look at the will to see how the testator intended for the immovable properties to be distributed, and then they will just process accordingly. So the differences between testacy and intestacy is the manner of distribution. Testacy, there will be in accordance with the will, and testacy will be under the act, the grant, name of the grant. One is called probate, one is called letters of administration. Disposition in accordance with the will, discretion, and this will be immovable property. The administrator cannot sell or transfer an immovable property without a high court order. Disputes under testacy is less likely. Of course, in some exceptional circumstances, people will challenge the validity of the will, saying that Peter was sick when he prepared the will, we should disregard it. But the threshold is quite high, because usually where a will is properly executed, it's witnessed by two persons. So these two persons will be able to attest to the fact that the testator was of sound mind and understood the contents of the will when he signed. So under intestacy, of course, the risk of disputes are higher. So next, what if there is a grant issued by a foreign court? Can this grant be used in Malaysia? So under Section 52 of the Probate and Administration Act, of probate in any part of the Commonwealth has either before or after the passing of this act, granted probate or LA in respect of the estate of a deceased, may, on being produced to and a copy thereof deposited in the High Court, be sealed with the seal of the High Court, and thereupon shall be of the like force and effect, shall have the same operation in Malaysia as if it were a grant made by the High Court. So in short, if you have a grant granted by a Commonwealth country, you can have it resealed in Malaysia, meaning, okay, you still have to file an application in court. It's called a resealing application. Let's say you got it from Singapore. So you file a resealing application in our courts here, and then the court will look at usually we won't get the original grant, let's say from the Singaporean courts. We will have one that is also certified true copy by the Singaporean court officers to say that, yes, this is truly the grant. So then we will file it in court. We'll provide the certified true copy to court, and then the court will also seal it. They will literally stamp it and say, yes, this grant is resealed and usable in Malaysia. Just to name a few Commonwealth countries: Singapore, Australia, Brunei, Canada, New Zealand, India, and Bangladesh. So if the grant is granted by the Commonwealth countries, you can apply for resealing in Malaysia. What happens if the grant is issued by a non-Commonwealth country? What can you do? For grant of probate and LA granted by non-Commonwealth countries, the estate's representative only has the option of applying for a fresh grant of probate or LA in Malaysia. You can't use it, you just have to file a fresh one. Usually for probate, they require the original of the will. I have at this point not done a fresh application for a grant of probate for an estate concerning a non-Commonwealth country deceased person, but I would think the procedure will also be to obtain a copy of the grant or the will, actually certified true copy by the courts from that country. That would be the end of my presentation. I will pass the floor back to Amanda.
Thank you, Mr. Jeremy and Ms. Daphne, for your insights on today's talk, Navigating Medical Negligence Claims, Guidance for Families of Deceased Patients. And now we will move on to Q&A session. It looks like we have a few questions from the audience. I will read out the first question. Okay, and this question would be directed to Mr. Jeremy. The question reads, How do we verify that the medical records and report given by the hospital is genuine?
Thank you for the question. So there's no specific verification process or procedure when it comes to medical records. You need to engage a lawyer who is experienced in medical legal cases to review the records and then to instruct an appropriate expert to give his or her independent expert opinion. Now, the expert may also address his mind to the completeness, veracity, and accuracy of the medical records. The genuineness of a medical report I would say, depend on the doctor preparing it. This is why it's important to obtain the contemporaneous medical records which were created at the time of the material events. In my experience, it's quite rare to see fraudulent records, though the courts have actually seen in a number of medical negligence claims situations where records were edited, they were amended, they were edited into after the fact. An experienced medical lawyer paired with the appropriately engaged expert of the right specialty would be able to notice issues in the records. Now, records as a whole, they can be electronic, handwritten. Most records in this country are now transitioning towards electronic records. And where there are electronic records, there are more often than not an electronic trail, right? In a past case of mine involving a patient who suffered a fall at the hospital, we noticed that in the records, for some reason, it seemed like a nurse at the time had gone into the electronic system and added words to the records to make it seem like she had taken a particular action at the time which was not present when she had made those records shortly after the event. What that nurse probably didn't know at the time was that we could see it. We could see the amendment. We could trace it back. And so we confronted the nurse in that case about that particular amendment. Of course, all medical records electronic medical records in this case, even handwritten ones have an accreditation system. So it's not so easy to manipulate records in this sense. Hopefully that answers your question.
Thank you, Mr. Jeremy. We have the next question, and this question I think would be best handled by Ms. Daphne. Can a non-resident act as an executor or administrator of an estate in Malaysia?
Yes, a non-resident can actually act as an executor or administrator, but then we have also seen situations where a non-resident has been appointed, but then there's some sort of delay in administering the estate, whether by probate or even LA, and then that would be one of the grounds, whoever that is trying to remove this executor or administrator, for them to rely on when they apply to remove. So they're saying they're abroad, they are not here, and it's inconvenient for them, and it's jeopardizing the interests of the beneficiaries of the estate. So they should be removed. That is usually one of the grounds people rely on to remove an executor or administrator.
Thank you, Ms. Daphne. And we have the final question. I think this would be best handled by Ms. Daphne also. But I think she was already going on about this point during her presentation. I will read out the question, and then Ms. Daphne, you can maybe just summarize your answer. Okay, the question reads, what if the deceased passed away in a non-Commonwealth country? Would resealing apply? And if not, what are the options?
Yeah, you're right, Amanda. I have already mentioned this. I think when the deceased passed away in a non-Commonwealth country and the grant was granted there, then the courts here would not reseal it. They will have to make a fresh application for the grant of probate or LA here.
Okay, thank you, Mr. Jeremy and Ms. Daphne. Before we conclude, I do have a few announcements to make to all participants. First, please do join us again for our upcoming talk, which will take place on 24th of July, which entitled Within and Beyond the Will, Strategies to Prevent Family Feuds. And also, please do fill in our feedback form and tell us what you thought of today's talk. The link to the form will be posted in the chat as well. And thirdly, kindly do follow and like our social media accounts. We're on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. And fourthly, if you would like to speak with our lawyers, we offer a complimentary 30 minutes consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. And to all our guests that took time to attend our talk today, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.